This isn't an actual recorded case, and that's why I'm giving you the sloppy or the catchy "why can't I be you" reference. In this case study, it came to us, the husband was breaking up with his spouse, and the husband had been the sole trustee of this trust from day one. We'll call him Mr. Y, innovatively. Mr. Y was also the primary beneficiary of the trust, and the wife was trying to argue that he had received distributions over time and she was going to be entitled to X percentage out of the trust. So a fairly standard blended family analysis of the family trust. We were called in because the wife's lawyer had the hide to actually read the deed. And the wife's lawyer rang us up on the side, or rang the other family lawyer up who rang us up on the side and said, have you read this thing? Because what this trust instrument says is that in relation to the definition of primary beneficiary, it's got an asterisk. And it says, in no circumstances will a primary beneficiary, even if named in the schedule, and it had one of those standard schedules, even if the primary beneficiary is named in the schedule as a beneficiary, that person can never be a primary beneficiary if at any time now or in the future they are a trustee. So from day one, that relationship had meant that Mr. Y was never a potential beneficiary of the trust, even though he had received all of these distributions out over an extended period of time. And all because no one had actually read the deed in the first place. So really, I cannot underemphasise how often that issue comes up. It is in virtually every trust instrument from a New South Wales trust deed provider. And interestingly, as I've touched on in that case study example, it's actually in countless other deed providers as well, whether they're based in New South Wales exclusively or whether they in fact are based in other parts of the country, because of this fact that most New South Wales advisors are so acutely aware of that requirement from a stamp duty perspective, they ended up embedding that into other trust instruments. So a really, really important one to be aware of.